Thank you so much, Raphael, for that very generous introduction. It's also a privilege and honor and just sheer delight for me to be here with you this afternoon for this lecture. I'd really like to acknowledge all the sponsors of the Keynote Center, and especially the Brooks Institute, for sponsoring this wonderful conference. I'm sure you'll agree that we've just been treated to one delight after another, and it's been so stimulating and energizing, moving, and inspiring thus far. I'm just so happy to be here. I'd like to thank Ava, Sean, and Raphael for just wonderful organization and the full organizational team, and also for inviting me to deliver this just recently published analysis in a journal called favour, which is a psychology of human-animal intergroup relations, launched recently at the University of Zurich. So I'd finally like to thank Professor Christopher Hopwood, who is leading that journal at the University of Zurich, who initially invited my contribution. Okay, so as we've been hearing, we are aware of, as the lovely chart that Raphael had for us at the beginning, at least for the past decade and a bit longer, of a growing global practice momentum of animal rights groups coming to courts, petitioning for some type of greater legal regard for animals. And this is sometimes a request for partial personhood or personhood status, or for one or more fundamental rights. And as we have heard about and been moved and inspired by, there have been some victories for animals from this type of litigation. And I don't want to dismiss the meaning for those individual animals who were liberated, or whose lives were improved in these cases, and what also the justices working with the laws that they have were able to accomplish. We also know that the judges here with us at this conference may be considered outliers among their colleagues in terms of the judgments they've delivered and responses to animal advocates coming before courts asking for some type of redress or remedy. And we also see that even when there are victories, right, that the type of animals that are at the suit or at the center of these suits are a specific type, right? The animals that are perceived as wild and properly residing not in captivity, but back in spaces that we imagine as wild. So the limits here are, of course, and as we've already discussed, some of the rationales for those limits in terms of more incremental steps, is that we're not seeing animals that are being liberated that are in the farm system or in other types of captivity. And as exciting as the deployment of the language of rights has been, we can also note, as we've talked about, that it's not typically holding the broad fundamental rights connotation in these cases, applying to all groups of animals, as Raphael also discussed in his opening in terms of, and Joe Wills as well, in terms of what characterizes a fundamental right in terms of breadth and robustness. Okay, so we can imagine quite easily, and we've talked about what are the reasons for this, I think justifiably classified lukewarm response across the board to test case litigation requests. One, of course, is legal conservatism, perhaps most heightened in the common law in terms of moving slowly or incrementally. And of course, another is the formidable psychological block of anthropocentrism, which I'll just unpack in a moment. But I want to suggest to you that there's also a further psychological concern here that can be influencing decision makers, and not just judges in courts, but also jurists in other fora, legislators who are meeting with stakeholders, lobbyists, or debating in houses, of the concern that is the title of the talk, dehumanization and animalization. And so by that I mean concerns not just about that if we elevate the status of animals, that we're going to desacralize humans or stain human dignity for humans across the board, in either a religious sense of human dignity that is motivating in some jurisdictions, or a secular sense, but that we're going to dehumanize or animalize certain marginalized human groups that are understood to be historically and still today marginalized in various jurisdictions around the world for various reasons related to race, caste, class, religion, gender, age, ability, so on. So I'd like to suggest to you that this concern over dehumanization and animalization was an influence in the 2022 Happy case at the New York Court of Appeals. And of course, the concern about race is not the only concern that has motivated the litigation going forward to that level in New York. Joe Will's wonderful article in a recent volume of the Journal of Human Rights and the Environment discusses how the issue of whether or not there would be dehumanization for people with cognitive disabilities would result from any elevation of animals. And I really recommend that article to you if you haven't had a chance to read it. I'd like to talk about race just because I see this as a key influence, motivating the majority judgment here, even when they've said kind of so little explicitly on race, and then motivating the dissenting judgments in replying to their colleagues. So we have a first kind of just entry point here for the talk in terms of talking about the psychological block of anthropocentrism, just to set us up to consider how the further psychological block of racial anxiety played out in the Happy case. And then I just don't want to leave that analysis there. I'd like to suggest, well, what can we do about this further kind of psychological block, right? If you're agreeing with me that dehumanization, animalization currents can be a further psychological block for decision makers, here we're discussing judges, faced with test case litigation, is the result to keep, which was the result by the majority in Happy, to keep in the Brainy decision about Happy, to keep humans and animals legally separate, the right one. I want to argue further that it's not. It actually, as the dissenting judges suggested to their colleagues, misapprehends, misconstrues the issue, and fundamentally doesn't help the anti-racist cause to keep animals subordinated. And then I want to suggest, using kind of existing insight and doctrine from non-Western legal orders, so going outside the common law and civil law, for example, to think of what a better legal response can be. It's not something we would have to invent, but can draw from, as we've already heard and been encouraged to do by our judges, to think of how humans can be approximated to animals in terms of species connection. And I'm just going to note that I think the timings are on the slides, Raphael, they're advancing by themselves. Okay. So if we just address that would be great.
They're dancing by themselves, in such a sense. The slides are dancing by themselves. They should be, I think, if you're in this mode.
Okay, we'll just continue on. If they are, I'm going to just double back. Thank you. Thank you, Raphael. Okay, so to be clear, really the gist of the talk is to consider how is the very valid concern about, not regressing in terms of human rights, and the very valid concern about dehumanization, animalization of human beings and denying their kind of equal status across the board, how is it that that prevents us from thinking about animals, and why is it, right? And so that's what I want to unpack in the Happy case, and suggest that wanting to kind of be on board with this image should actually incite us and entice us to be on board with this image. Right? And I should also note as a disclaimer, I did submit a scholarly amicus brief for the New York Court of Appeals in the Happy decision, which was not cited by any judge. And so I just wanted to make that clear as I talk about my analysis here. Okay, so let's just think about, the first kind of perhaps overwhelming formidable block of anthropocentrism. So I don't want to suggest, in suggesting that there is this, overarching kind of hegemonic way of thinking, that there isn't legal or cultural diversity around the world in terms of how different human cultures think about animals. Of course there are. We've seen that temporarily. A very famous example that people talk about is animals standing trial in medieval England and elsewhere in Europe. And we see that even in the current day in different countries because of how certain animals are regarded vis-a-vis others in a particular religion, culture, and then national jurisdiction. So you could think of an example we've already had, the cetacean ban in Canada, right, in terms of this humanized type of status for really whales and dolphins, and cow bans in India, right? Even as much as in both cases they're not properly enforced, at least you have these prohibitions when most other animals don't have these prohibitions attached to their captivity or even to their slaughter. And as many scholars have noted, we can even see that cultural variation in how anti-cruelty legislation works, in as much as this type of legislation is so prominent in different jurisdictions worldwide. In some countries, you will see very kind of bare bones legislation, everything very kind of implicit. In other countries, you will see more explicit provisions. And then, of course, in some jurisdictions, we see constitutional kind of recognition of animal sentience above an anti-cruelty statute, and just a regular, ordinary piece of legislation. At the same time, despite all this, variation, we still have a very prominent undercurrent of animals being treated as property, right? And so whether we think of that as a bit more than property, as we've read and heard about, we can still see that the overwhelming status for animals legally is one of objectification and commodification. And again, it's not difficult to understand why this is occurring if we remember that laws are informed by cultures, right? And then we think of what is the kind of the cultural valence to these laws. And as Angela Fernandez has suggested in her wonderful piece in the Brooks U Fundamental Series on quasi-personhood, quasi-property, there is still, despite precedent for non-human personhood, for example, or other protections, this type of outrage factor that seems to be animating humans when they're faced with any type of kind of request, or most humans, for requests to put animals on par with humans as kind of personhood seems to be asking for, right? And in her kind of fulsome comparative common law jurisdictional survey from just about 15 years ago, personhood scholar Nagar Naveen has noted that even as the concept of personhood has not really been well discussed in courts, it's kind of this foundational pillar, but nobody really talks about it. Even when we do, it's kind of vague, has different meanings, right? And some of it really religious, even in societies where it claim to be secular in terms of this, religious ideas of human dignity. That, her sense is that even though we have precedent in the form of corporations or other non-humans having this coveted legal status, and even as some of us have argued and signed on to kind of amicus briefs here about how anti-cruelty statutes could theoretically, to the extent that we correlate personhood with rights, and to the extent that we locate simple, what we may call, and scholars here have called simple rights or small r rights in anti-cruelty statutes, you could source precedent for animal personhood, perhaps even coming out of anti-cruelty legislation, let alone going over to kind of corporations and ships and municipalities as examples of non-human personhood. So Naveen has said, despite this type of available existing argumentation that should be legally persuasive, right, if properly carried through, you have a sense that extending this more broader legal protection to animals, personhood or something equivalent, is seen as preposterous, right? And then we can think of that as this outrage factor. And in her discussion of animal sentience recognition in various jurisdictions, Charlotte Blattner has kind of taken some time to think about, well, what causes this anthropocentric block? What makes up anthropocentrism as a real hard psychological wall that is hard to, go past for many of us? And she talks about 4 different types of cognitive biases that make up an anthropocentric psychological block. So self-serving bias, which is a cognitive bias of preferring our own interests over others, right? Status quo bias, which is closely related, of not wanting to change because we prefer not to change over changing, even if change would be better. Loss aversion bias, where we value losses over gain. So even if we, perhaps stand to gain a little more, if we're still going to lose, even though the net result would be a gain, that's psychologically difficult to pursue and select. And then also something called scope insensitivity bias, where when what we need to be moved and troubled by a problem is related to just the colossal scale of what is going on, or the suffering, as we know, if we even just think of farmed animals on land, let alone aquatic animals, it's very hard to perceive that type of scope and scale, and it's more of like a turn-off mechanism to even try to think about it. Okay, so that all sounds formidable, right? And then we can understand how these types of cognitive biases have stopped most decision makers in law, judges and otherwise, from approximating humans with animals legally, even as they accept long-standing Darwinian conclusions and teachings, right, here from Cambridge and elsewhere, popularized throughout the world, that we're on biologically a continuum and there's no sharp divide. Yet we have this sharp divide in law. Okay, so that's a bit of a doom and gloom situation, but we can also think of kind of greener pastures and a different type of thinking, and we have witnessed, right, three wonderful speakers with us today, here in person and also joining us virtually, where we have seen thinking that has gone against the conventional grain. And we know that psychologically it is always possible to challenge any type of hegemony, right? Critical thinking is always possible. And if we take Gramscian theory, we understand that hegemony is never total or complete. We can always move and act differently. Okay, so how is it then that what I've said about the anthropological block being kind of, or anthropocentric block being a formidable kind of first layer psychological concern, now can relate to what I'd like to discuss, which is this further psychological block of dehumanization, animalization. All right, so let's imagine us all as judges, right? Or let's imagine our friends as judges. Let's imagine our family members as judges. Perhaps let's pick somebody. Does everyone have someone in mind? Okay, so we can think of them as perhaps surmounting the anthropocentric thinking, right? Now, what else might influence them in their decisions? Well, the legal kind of incrementalism and the good reasons for that we heard about. Also, the institutional roles, one of the questions we had in the panel, and the good reasons for courts maybe to defer to legislatures and to parliaments. But we know that these reasons about kind of, going slow and not making grand change in the law, and then, having a proper sense of institutional roles at different human rights points in human rights legislation have been accommodated and kind of diminished in importance so as to affect the big judicial change and judicial step of not a baby step, but of a grand step, right? And certainly the Non-Human Rights Project that has brought the Happy suit, the Penny suit, and others, and other animal rights groups have encountered this type of argument and have replies to them. Okay, but now let's imagine that we have a judge who is, willing to think about animals in a very different way than the mainstream, is willing to put aside the kind of legal conservatism concerns about not being overruled and because of not staying maybe true to precedent or institutional roles. Now perhaps there is a further psychological block that is going to kind of prevent them from, having kind of a more responsive response to the petitioners coming forward. And this is what I'd like to talk about, the concern about dehumanization, animalization in the form of what I and others call racial anxiety. Okay, so we can understand racial anxiety as a concern that racialized groups, right, our human groups are going to be dehumanized and animalized. And so let's just pause, because we often hear these types of nouns and adjectives, and the obvious inference is that these are negatives, right? It's a negative to be dehumanized, and it's a stigma to be animalized. And we can certainly understand where we get that inference from, right? So, we'll just get that back and forth. So we get that inference from the history, of course, in a particular jurisdiction. Of course, Happy's coming out of the United States, and we're likely very familiar with the fraught history that connects race, species, animals, and animality in the United States, but also in other jurisdictions in a variety of different configurations. Professor Fernandez also says in that article, it's not clear, though, that the racial anxiety that some have with the comparison is going to go away. And then what I'm suggesting here, now that we have post that scholarship, the 2022 decision from the Court of Appeals, we can, that and is actually featuring Happy, we can see that it hasn't. Okay, so now let's turn to this decision. And what the slide would have shown, basically 4 quadrants, right? So let's imagine 4 quadrants, a slide, just in our minds, 4 different rectangles. And if you think of 3 of those rectangles are slaves, women, children, and you think of the 4th as being animals, that's what we'd like to see. So in a nutshell, and I don't want to diminish the multi-layered analysis that both the majority and the 2 dissents did in Happy's case, right, and focusing kind of on the racial anxiety discussion going on. But in a nutshell, how can we understand the difference between the majority and the dissents? Well, the majority was willing and right on board with really kind of subtext of moral legitimacy and legal legitimacy of seeing habeas corpus as properly extended from the human slave context, from married women context, to the children under their patriarchal fathers and parents context, right? And so did not see any, and did not articulate any qualms about that extension, right? And of course, where there was a hard block for the majority was to fill the 4th quadrant with animals. Whereas the dissent would have filled that 4th quadrant and continued that extension with animals. Okay, so some of the scholarship that addresses comparisons with, Black slavery in the United States, or Holocaust in Europe, or genocide for indigenous peoples across the world, and considers, what are the pros and cons, or what are the ethics of comparing kind of these human injustices and using those examples to make visible to people the concerns about animals today. And there are different opinions on that. I myself have written about this on different issues. For example, PETA's use of kind of sexualized images of women's bodies to make the case about the dairy industry or otherwise. The majority then really is of the view that the comparisons are wrong, but part of why scholars who perhaps have more room and more capacity, given it's their field of interest, to probe the issue of comparisons a little further, they've suggested that one of the problems of making comparisons is that the singularity of the experience is reduced too much. So the singularity of the Holocaust, or the singularity of African American slavery in the United States, or the singularity of how children are positioned vis-a-vis their parents when the law is not protecting them, even today at the same level. That when we start drawing comparisons, it's too quick, it's too reductive then as a result, and then we're losing a lot of the nuance that we shouldn't be losing. And that's not really kind of right or effective. And it's also alienating to groups who are very invested in an identity of related to that injustice. Okay, so what I'd like us to know is in the majority judgment, we didn't hear anything drawing from that scholarship about the singularity of the experience of human slaves, right? So Black people in the United States, given the context, married women of all races, and then children, right? So what I'm suggesting that we can see that there was no concern about extending, despite, even in the human sphere, the singularity of these experiences, right? And what could be reduced by extending habeas from one sense to another and talking about these oppressions in one kind of under one umbrella. Okay, but this is the concern with taking it over to animals. And at this point, there would have been a lovely picture of the court as it was then constituted. And I think it is important to note just kind of the gender racial mix of who was in the majority and who was in the dissent. Not because that is like the final determination of how we should perceive their comments, not at all. But in terms of responding to concerns that I'm sure we're all aware that animal rights is some type of white pursuit or Western pursuit or, otherwise elitist, we see that the dissenting judges themselves, if we can take anything from visual expression and photos and their backgrounds on their website, which as I did, are racialized judges, right? So the two justices in dissent are racialized judges, and we have a mixed race, mixed gender majority, and a mixed gender, a male and female dissent there. So I think that's important to bear in mind as we think about what their comments are saying. Okay, so I will just read the very little text I had in the slides, kind of trying to adhere to that instruction we were given from a wonderful kind of teacher from a few months ago, which is basically what I would say is the crux of the majority opinion that showcases their racial anxiety. Okay, so let me read it to you. And here they are talking about their colleagues' dissents. The dissenters conclude that the logical progression of our common law runs from extending habeas to abuse women and children and enslaved persons, to granting an elephant the right to bring a habeas proceeding, an odious comparison with concerning implications, as both dissenters acknowledge, but one on which they nevertheless rely. We are unpersuaded. Okay, so these are colleagues talking about their other colleagues. And in law school, I did take a comparative constitutional law course, or one of the comparators in the United States and India and other England. And I saw that there was different judicial kind of cultures about how people talk back and forth. And Canadian judges are a bit more reserved and nicer, I think, to their colleagues. But this is a very hard-hitting word, even in the context of a jurisdiction where there's sharp language going back before the majority of the dissent. Odious, if we look that up, and we can, right? We are going to see synonyms like devastating, detestable, hate-inducing, hateful, right? It's a different level of kind of negativity attached than to, let's say, concerning, troubling, perplexing, right? And so this is a majority talking about their colleagues, that this is odious, right? And so I would suggest to you that kind of confidence in using such a loaded term, right, it comes from the sense that what their dissenting colleagues are suggesting is racist, right? And we're not calling it out as such, but that this odious is really a coded word for saying what is going on here is really racially problematic and it is coming to the word of odious, and we're not going to go down that line with you. Okay, so that's where I would suggest is kind of the majority display of racial anxiety. The majority judgment compared to the dissents, not too unusual here, is not too long, right? And so there's nothing really otherwise explicit about race coming out of any other paragraph. But if we think again, right, that how they talked about the comparisons across human groups, and now they want elephants, and this is odious, my suggestion is that this is where we can see the racial anxiety. Okay, and so now we would turn to a lovely picture of Justice Wilson, and let's talk about how did now the dissenting judges respond to Justice Wilson, to the majority, right? So let's look at Justice Wilson's judgment in dissent first. It's the longer one, and so what I want to suggest here is that we can see kind of the concerns about dehumanization and animalization. Here we're focused on race, kind of really taking up a huge chunk of the dissent's now kind of answer or response to the majority. And it's done in quite a remarkable way. So on many registers, Justice Wilson's judgment is just amazing, right? So he he starts off very strongly with talking about the image we saw from Justice Mina's wonderful presentation yesterday with Ochabenga, right? And so the Wildlife Conservation Society, current operator of the Bronx Zoo, we're happy is still located in its current, previous iteration is in New York, Zoological Society, showcased, right, African humans in the same space and along with animals. And he starts off the judgment talking about that, right? And then also talking about and intimating about the colonial raison d'etre of zoos. What are zoos? And what were zoos? If we look at the scholarship about zoos, thinking about the London Zoo, we also heard about Regent's Park and how the naturalists came together. It's very much formed by the experience of what colonialism is in the British version, but also other iterations of showcasing what's out in the colonies in terms of flora and fauna and bringing it back to the metropoles so people can watch and display and see a curated kind of experience of what's in the colonies without actually kind of being there. And so Justice Wilson starts by kind of alluding to this history and then saying very quickly that the point he's trying to make is to say that captivity had devastating consequences for Ochabenga, who, as Justice Wilson, reminds us, shot himself in the heart after he was released. And it also has devastating effects for certain category of basically autonomous animals who are also in that same position. Justice Wilson goes on to make further connections between the experience of human captivity and animal captivity, in the sense of talking about how agitation and advocacy for dealing with human-based oppressions with respect to slavery, with respect to cruelty against children, with respect to women's rights, shared a lot of overlap and synergy, so a second critical connection is made. He also makes the point that we believe in Darwin, right? We understand these teachings for a long time, so why would we think that there is no kind of capacities of animals to suffer in the same way? And what I also find just so remarkable about the decision is that it's a moment where he talks about like humility and stepping away from human hubris, right? To say that, it goes back to the precautionary principle that we heard about as well, that we can't really ever know what an animal is experiencing. We can't get the full extent of that suffering. So let's defer on the cautious side that we don't know, right? And so the better legal response is to, favor the interests of the animals rather than not favor. So by so many registers, Justice Wilson's dissent is a huge challenge to human exceptionalist thinking. And he even uses the term human exceptionalism in his dissent. I mean, that's amazing, right? We don't see even this kind of more scholarly term coming into legal doctrine, right? Okay, so many wonderful things to say, but the takeaway here is not to kind of consider how the dissent is, when I'm arguing, or what I don't want to be arguing centrally, so much better than the majority. What I want to bring our attention to is that the racial anxiety that the majority expresses that I've suggested is now also here in the dissent, despite everything now that Justice Wilson has said. Because either as kind of a concession to the majority, where it's a strategy, a choice to try to bring them along, right, and agree with some of what is being said, or either because Justice Wilson really does believe what he's writing. We also know in the judgment, in the opening paragraphs, that Justice Wilson started out by saying humans have more rights than elephants, right? Either because we make the rules, but then we get other kind of indications from him that even if habeas protection is warranted and should be the legal result in this case, full personhood isn't. And that is because of the concerns that then Justice Wilson, after he did all those wonderful connections, in my view, starts then talking about why it's so fraught to talk about human injustices, its specific types, now in correlation and through an extensionist ideology to animals, as he has drawn those connections through the habeas common law literature and jurisprudence to animals, right? So now he takes pains to go to certain critical race theory, right, and talk about how often these extensions and comparisons are done very bluntly, and singles out PETA for their campaigns in this regard, suggesting even when there's not the intention, it has had a dehumanizing, animalizing effect that is racist. And he calls our attention to the need to, right, productively think about how to make these comparisons in an anti-racist way. And then he does start talking about, we can draw from indigenous legal orders, which have a different starting point for who animals are, how they relate to humans, and what their legal status is, right? So we see a more normative legal person for animals that is not something new, but something very long-standing and kind of foundational in other legal orders. But Justice Wilson kind of, doesn't pursue that too long. Instead, he comes back to a position to say, let's not go down the road of personhood for animals, right? And so that's irrelevant to this case. We don't need to do that. But he does say we don't need to make personhood is probably not productive to pursue for animals. Now, I myself have said the same thing in my book, but for different reasons, right? So not for the reasons of dehumanization, animalization of human beings, and that's a need to kind of think of a different pathway. So the point here is that even as Justice Wilson is trying to make such inroads and is trying to show why the majority's kind of take on the issue is misguided, right? We can see either because of concession or perhaps, and we can understand as a capitulation or a real kind of investment of his own part in keeping animals and humans separate in terms of something that is larger than the habeas protection, right? So we understand this person had another equivalent status. Okay, so if we followed up till now, what I've suggested is the majority and Justice Wilson's judgments are kind of influenced by this concern of our racial anxiety, which then has resulted in a legal outcome of separation on personhood or something as equivalent, not for Justice Wilson, but not on habeas. Okay, so now let's think about Justice Rivera, who, even though she endorsed Justice Wilson's judgment, found that she needed to also have her own judgment and say things that she found to be important. All right, so it's arguable that her judgment is even more challenging of human exceptionalism than Justice Wilson. Again, that's not my main argument, but in terms of giving her credit, how does she start off? With very strong words, right, in reply to her colleagues, taking us back to basically the space where Happy was taken as a 1-year-old from Thailand, right, and she mentions from her mother's, grandmother's, sisters, all the female relatives she would have been raised with and forged with and socialized with, and had she been allowed to live her natural life. And then where is she put? She's put in a zoo, and Justice Rivera uses those words on display as a spectacle, right? And how is a zoo organized, right? Iris Graberman has just done such interesting work about, how zoos are organized and the political nature of zoos. But Justice Rivera says, what are humans doing? They're looking down on her, right, as they're coming into the elephant exhibit, and what is Happy typically doing? She's swaying and she's moving her foot, and the zoo advertises this as come to Asian wildlife land where you're of learning and natural kind of exhibit learning, and Justice Rivera says this is a fantasy, right? The zoo is marketing a fantasy. This is not what Happy is experiencing. In fact, Justice Rivera uses the term for elephants, this is a miserable existence, right? And she quips, Happy is anything but happy in this type of existence. And in addition to kind of all of that setup, Justice Rivera, kind of goes further here in Justice Wilson and really taking on the majority's characterization of what they're saying in dissent as odious, right? And she says the majority has misconstrued and mischaracterized profoundly our judgments as odious, and accuses the majority of tautological evasion. It's basically circular thinking, saying humans are the only ones entitled to habeas corpus because they're human, right? And so, as she's like, this makes no sense, and this is precisely the question that we need to answer, right? And then she goes kind of through her kind of emphasis that she wants to give of the evidence, saying, you know, she feels like that she needs to write for herself, just to say that none of the precedent that has been argued to kind of preclude this legal remedy of habeas, actually, that's not compelling argumentation, and here's why. And in doing that, she's still taking on the dehumanization, animalization concern further, because she says that the odious comparison is mischaracterizing and is misconstruing, and it's just wrong-headed. And the majority is forgetting all of the history from the common law very conveniently that the dissent is trying to make visible. At the same time, Justice Rivera, I would suggest, is also influenced by a type of racial anxiety here, either again as a concession to the majority, or in terms of trying to dialogue with them, or because this is something that, you know, she really does want to emphasize for herself. And she says, look, right, no one is suggesting that elephants are like these other categories of humans. And Justice Rivera does mention more than race in terms of thinking about people with cognitive disabilities as well. And so again, the inference from that statement is that it would be wrong to think about animals as equivalent to humans, right? So she's saying, that's not what I'm saying, to be clear, right? She starts off one paragraph to say, to be clear, this is not what I'm saying, right? And so we have to think, like, where is this kind of to be clear paragraph coming from? Why does Justice Rivera feel compelled to be clear on this point, right? It's because it seems to be such an influence for the majority, right? And likely very well aware of public perceptions that she then wants to answer to. So she doesn't seem to get to the kind of no personhood for animals result that Justice Wilson does. And so there might be kind of more of a opening for her to bring human and animals closer together. But the point here is not, you know, where does Justice Rivera stand on the approximation on personhood or something equivalent, but to show that even though Justice Wilson had a very comprehensive kind of reply in dissent to the majority, Justice Rivera has a more than passing response about kind of the race issues and dehumanization, animalization issues that the majority, in their one very loaded paragraph, seems to be worried about as being odious. And this is even though she had that language in the beginning of her judgment, and she uses very, you know, hard-hitting language herself to say, to keep elephants and animals who are autonomous at their level in this type of situation of captivity, even if care is amazing, it's the best zoo in the world, is an affront to humanity, right? It's an affront to civilization, and it's just fundamentally unjust. So to understand my point there is that she's very emphatic about the unjustness of what is going on. Yet at the same time, she makes comments like, no one is saying that animals are like humans, with the inference being that no one is saying animals are equal to humans. So, what can we take from this? Now let's just pause and think. What is happy about? Right? If we didn't hear anything about this case and someone was giving us the facts, we would have understood that Happy is an elephant at the Bronx Zoo who has been there for decades, and we now have an animal rights group called the Non-Human Rights Project trying to do something about this captivity. Now, and then if we said to our students or otherwise, what would you expect to hear from the judges? Like, what type of responses? Here are the submissions, what do you expect to hear? It's not clear that the response is going to come back. Well, I expect to hear a lot about dehumanization, animalization, kind of concerning implications, odious connections about race, disability, otherwise. And actually, we don't hear that much about disability at all. Just as Rivera mentions cognitive abilities, and just as it's really, I would argue about race in this case, given the American context. And so that's not a natural progression, right? To think about a case about animal captivity and to have all this discussion about racial anxiety. We understand the history leading to this, right? And then we can understand that this is a 2022 case, which was like 2 years after the events of 2020, right? Which had certainly the influence in terms of the murder of George Floyd and having the influence in the United States and actually more global registrar. And so as many have suggested, what has it done? That has taken what has been usually kind of not for public conversation, and certainly not for mainstream kind of thinking, dialogues and recognition of, oh, there might be something called systemic racism. Oh, yes, there might be kind of structural issues in a society that are very, racially unfair. And oh, yes, racism might be an ongoing thing. To a more public conversation where more and more kind of people in the mainstream are aware of these issues and wanting to do something about it. At the same time, we also have, scholars and commentators, including racialized individuals, who comment that the dialogue is now very polarized. And so the concern in a public sphere, and you can't get much more public than being a judge having to deliver a judgment out into the world, right? And so we can imagine that, even if you're a legal decision maker that wants to do something really great for animals, you now might be concerned that if you start making connections between kind of human injustices, especially on grounds of race, to animal injustices, you're going to be called a racist, right? And that is like something nobody wants to be called. And so you might kind of, dim down what you want to say, dilute it, diminish it, not because you have the concern, but you perceive it now in the public or in the public dialogue that has become very polarized and kind of harsh in response in terms of public statements and what should happen to people's careers and reputations because of it flowing from that. So, and I don't want to suggest, as much as, since the events of 2020, we might be having more public conversations, that the racial subtext to kind of the animal liberation question is something new. It's probably more best understood as like a substrata of discourse, that it was always kind of operating at a psychological level for decision makers, at least those who are somewhat informed about, kind of history and social politics and injustice issues. But what we see in the Happy case is a kind of a more explicit airing. I mean, even Justice Wilson talking about like critical race theory in an animal case is, it's surely a first. If someone knows it in another context, please let me know. But that is surely a first, right? And we have Justice Rivera using the terms white supremacy in her judgment, as well as dominant patriarchal thinking. And so these are terms that are usually like an academic speak, right? For those of us going through feminist theory and anti-colonial theory as I did as an undergrad. To see it in a judgment that's meant for mainstream public consumption is quite remarkable and I think quite telling. So racial anxiety being a concern here, we're seeing, I think, a more public airing between the majority and the dissent. But I don't want to suggest that this has never gone on psychologically for humans before. Okay, so now, if you're kind of agreeing with me that there is a further psychological block beyond anthropocentrism, so let's just recall, what's the anthropocentric block? Humans are special, animals should not be raised to their level legally because that means humans would no longer be special and we should be superior and dominant and animals aren't our equals. That's the standard psychological block, right? And we know that there are more specific cognitive biases that make that up. The further psychological block we're talking about here is dehumanization and animalization of specific human groups, and further, more specifically, in terms of Happy case on race. And so what was the legal result? Even on habeas, it was a legal separation between animals and humans, and certainly on, let's say, larger legal status, like personhood, a clear separation. Is that the right response? Do we have to keep animals down and not elevated to a similar legal status in order to safeguard kind of hard-won intrahuman equalities that actually aren't yet, hard-won across the board, but at least formally in law? And so here comes the second part of the argument, which is to say, no, that's not the right response. And so how can we, unpack why that's not the right response? Well, I would go to just kind of the scholarly literature in socio-legal studies, but also in feminist theory quite prominently, but elsewhere, that suggests that there is a tight correlation between human injustices and animal injustice in terms of the trope of animality that undergirds kind of why humans have been subhumanized, the dynamic, and of course how we talk about animals. And Cartesian dualism, so things like we elevate the mind over the body, reason over emotion, culture over nature. This type of ideological thinking that has been used to rationalize, tell stories about why animals are lower, and it's also been used to tell stories about why certain groups of humans are lowered and shouldn't be in the public sphere or paid at the same level or, be seen to be a legal person or what have you. And so there are many racialized scholars whose work is to point this out and who talk about how there's a mutually constituted nature between how animals are treated and how marginalized human groups have been treated, right? And so the answer there is not to disregard the plight of animals, to think that it's unrelated, but actually to integrate the plight of animals into thinking about how to undo something like racism or sexism or ableism. And I just want to mention the work of Jishnu Majumdar, whose a recent work I reviewed in Well, which is published in the Journal of Political Theory, where he has a really great analysis about John Locke and Lockean theory, especially, which we know is so critical to kind of foundations of the common law. And his analysis is that if you take a deep dive into Locke's theory of human equality, you will actually see it's not just bad for animals in terms of a human-animal divide, but it actually depends on kind of racism. Right? So it's not just subordinating animals when we think of human equality as being sustained by keeping all non-humans below humans, but it actually encodes kind of a racial foundation to societies that think about Lockean equality as the basis of their common law. And so that's just but one example to think of the mutually constituted nature, and it's a very kind of hard-hitting legal example. Okay, and so to go to the last point now, how can we think of, how can the law move differently? What could we then, as scholars, advocates, other professionals interested in encouraging a different legal outcome, how could we put it into words, perhaps from the scholarly academic jargon, that could make it into like a legal submission and then go forward into a legal judgment. And so here is where I think it would be great to draw from some of the concepts, right, that we've already heard about from other jurisdictions, from non-Western jurisdictions, which have, I would say more so than common law and civil law, more examples and a longer history of thinking of humans as animals, right? So Justice Wilson, especially Justice Rivera, point this out, we are animals, but what legal orders actually reflect this back to us, right? And we can think of indigenous legal orders, Amerindian or worldwide. We can think of rights of nature, for example, as we talk about the Ecuador context. We can think of how Justice Manila, excavated the right to life from kind of the Pakistani context and Sharia law and common law together to think of, how is it that there are so many other examples where humans are actually in close proximity to animals and maybe not even seem to be like separated, that there's not even a category of humans and animals, right? It's much closer, and you have a longer tradition of interconnection legally, not just kind of spiritually or religiously or ideologically in terms of the cultural thinking, but actually legally. So Justice Wilson, if you recall, in his dissent does reference Native Americans in this sense and their legal orders, but that kind of gets closed down fast and doesn't get exhumed too much in the judgment. And so my hope would be that going forward, that type of like other thinking about other than humans could come in and wouldn't mean reinventing a whole wheel, right? You have other doctrinal traditions available. And let's just now think, right, about the end result for Happy. She's in the zoo. The zoo, as I've suggested, drawing on scholarship of others, is an imperial apparatus, right? If Happy had been released from the zoo, that can be perceived as an anti-colonial moment, a big anti-colonial gesture. If all zoos are closed down, that is stopping an imperial practice, right? And of course, it's more complicated, and we can characterize zoos as otherwise. But there's a strong anti-colonial argument for saying zoos are wrong because of the histories of colonialism. They're wrong today, even as animals continue on in that, right? But that type of analysis wasn't visible to the majority, right? That specific element of analysis doesn't come out in the dissent about the central history of zoos, very prominently. But there is a different way to perceive on anti-racist, anti-colonial grounds that seem to animate the majority to think about Happy as a freed being, as being an anti-colonial, anti-racist moment, right? Of course, just depropertizing animals can be read as a core anti-colonial outcome in terms of how we think of how did animals become propertized across the world in legal orders, right? So that itself. But certainly, if Western legal orders and jurisdictions were to integrate more from the non-Western legal orders about animals, and again, we don't want to romanticize or homogenize, so I hope I'm not doing that, but there are things to draw from that can be good lessons in thinking that, you know what, we don't have to start from a space of abject animality as the common law does, as the civil law does. Racial anxiety, other anxiety makes no sense if animals aren't seen to be inferior in the first place. Animalization can be a positive, and is, right, for other human cultures in terms of close identification with animals, and family and kin and clan identification of animals, and in a context of public speaking, coming out and saying, this is my animal clan. Right? So it can certainly be positive and not a source of stigma. The Happy case is coming out of a particular cultural context. Right? So we're not dismissing the cultural context, we have to grapple with it. So this is how it concludes. As much as we might say, there are so many ways to read a liberatory outcome for Happy as an anti-racist, anti-colonial outcome. The reality is, most judges and most of us in the public can't get to that reading right now. Right? We can't frame it that way. It's going to take a lot to kind of be on board with what I'm saying. Okay, so then let's help our legal decision makers, if that's our professional, personal life's work, to try to get there, and their tools to do so from other legal orders. In closing, I'd just like to bring it back to Happy, and I'd like to dedicate this talk to her. Unlike us, we know where she is, and we know that existence. And I always think it's, for myself, important to, whatever I might be arguing on paper or orally, to consider how would this land with the animals I'm, speaking about, right? And I have the privilege of doing so. And so I do think, if Happy were able to grasp the totality, perhaps she is, of what I'm saying, that she would likely see the whole race discussion and implicit, coded, subtext, explicit, as a distraction from what should have been the outcome of the judicial debate and discussion. At the same time, because of human psychology and for the reasons I've suggested, we have to kind of meet our human decision makers where they are. And the hope going forward is that the next case, and hopefully Happy's, there's some recourse for Happy, we can get to a different shifting of the legal conversation using kind of existing tools in non-Western legal orders that start from